I propose that the physical infrastructure should include disability friendly. No, because I was told that you will want to do it as part of regulation. Then read that rendition because it's not.
Leader, it's been captured. And there's a separate clause that deals with that.
Which clause is that, Mr. Speaker?
Is it 47?
Yeah. Hold on.
So once we are going on, can I put the question? Very well. Honorable members, 22 as various.
What is that? Read exactly, don't confuse me. What? No, read exactly what you are saying is being captured. That is already there. We're dealing with physical infrastructure. Mr. Speaker, you go to some of these institutions, there are lecturers here. You know that in Ghana, disability-friendly infrastructure is non-existent. You read it. If you say it is provided somewhere, you read. Read exactly what is there. You should read. I have it here. It doesn't say so.
Admission measures for persons.
Admission measures for persons with disability. An accredited university may adopt special admission measures for the purpose of increasing the representation of persons with disability in the legal community. 2. In furtherance of subsection 1, an accredited university shall A. adopt special measures to enable students with disability to pursue legal education. B. Maintain adequate infrastructure which are accessible to persons with disability. And C. Make any other provisions to accommodate persons with visual, hearing, or any other form of impairment. Mr. Speaker, I so read.
Thank you.
You see, that provision deals with non-discriminatory admission measures. And then it goes further to talk about admission measures for persons with disability. These are separate in form and shape from the standard for accreditation of universities. Mr. Speaker, my submission here is that ab initio, when you want to have the criteria for accreditation, this must be fundamental. It should be part when they are going for inspection. They should also cite the physical infrastructure at the various universities. Okay, having disability-friendly structures. It should be part of the criteria for the accreditation. Yes, that's a C. So it should be provided. Instead of talking about admission measures for disability, what that here, the difference between what we are reading in 45 and the 22 is that there is no prerequisite. Wait, you would have to no. Would
Honorable, please.
They have different headings. Let us deal with the fundamental issue. The fundamental issue here is standard for accreditation in all these universities abroad. The issue of consideration when it comes to disability is very fundamental. And I'm saying that if in your standard for accreditation, you are saying that there must be requisite physical infrastructure necessary for running the program and operations of the university, it is proper to qualify it to add that requisite physical infrastructure with disability friendly facilities. So I want to insert disability friendly facilities to be inserted. Then you follow with necessary for running the program and operations. That's all I want.
Chairman of the committee, I don't know whether it will be possible to import 47B, maintain adequate infrastructure which are accessible to persons with disability. Can we import it to 22? I don't know whether I'm making sense. Can we bring it to 22 so that it becomes part of the standard for accreditation?
Speaker, then we may have to insert
legislation on that.
Yes, Mr. Speaker, there's a whole statute on that already.
Yeah, there's a statute on that.
So what we have done with this legislation is to craft a whole session for that. But if it is insisting, the Disability Act, we have a Disability Act, and there's no way. Oh, leader, you have made your point. So listen to me also, let me make my point. I'm saying then it means that at every stage of the requirement in this legislation, we may have to insert some provision on to cover persons with disability. It's not really necessary, and that's not how we legislate. Once there's a provision to cater for their interest, it suffices.
It's enough.
It suffices, especially when we are asking the minister that within 10 months. Normally we don't do that. We say 12 months, but now we say 10 months, isn't it? That 10 months. That we say within 10 months, you must bring regulations to give effect to this. And the regulations, we will be able to bring regulations and guidelines to fine-tune these things. So it is needless to say that because this provision is on standards for accreditation, we must willy-nilly insert a provision to cater for the interests of the people with disability, as though we don't have them in contemplation. We do. Because the regulations, when the standards are set, it will specify exactly the checklist to tick in order to get accredited.
Chairman, let me listen to
Thank you, Mr. Speaker. Mr. Speaker, the 2E. Yes, please. I have a proposed amendment that a balanced student-lecturer ratio.
Hold on. Let's finish with this.
Okay.
Adam, hold on. Let's finish with it. So, Chairman.
Yeah, Mr. Speaker, I think that in appreciating this, in appreciating leaders' concern, we have to start from the preambular statement, and that is from 2. So the head note says standards for accreditation, and 22(1) sets a certain threshold. 2 says that the council in setting the standards under 1 shall have regard to the availability. Mr. Speaker, if we now transpose a statement to C, requisite physical infrastructure. The word requisite encompasses. That is what it means. Requisite means that pay attention to available legislation that has to do with disability and other laws. And so have regard to the availability of requisite physical infrastructure. Requisite physical infrastructure will include provision for disability, provision for all other things. And so that is defined in those 3 words you see, requisite physical infrastructure. So, Speaker, there's no point in changing anything in this. Leader, respectfully.
Well, Mr. Speaker, I respect the views expressed. Let me put this across. To the extent that Chair has explained that the phrase requisite physical infrastructure as used is a term of art that explains an inclusive sort of structure to also mean that that structure itself would be disability friendly. Mr. Speaker, I'm sure when any court of law is called upon to interpret this, due regard will be given to this debate. But isn't it also okay to bring clarity if it means being superfluous? Why would we get the matter hidden when we can make it open? Mr. Speaker, the explanation that he has given, is simply that, when the drafter stated requisite fiscal infrastructure, that phrase implies that the infrastructure must be disability friendly. That's what he's saying. But, Mr. Speaker, I am saying that I would yield to him, provided that at any point in interpretation, the records of this House will be a reference point that this is what the legislators meant when they used this phrase in this enactment. Because, Mr. Speaker, it has happened before. In the famous Benjamin Mensah, it was the debate of this House that aided the Supreme Court. So, Mr. Speaker, I am happy that the Chair has explained that this phrase, requisite physical infrastructure, also mean that physical infrastructure, that building, must have a disability-friendly facility. Mr. Speaker, that being said,
thank you very much, Leader. So, honorable members, clause 22, as variously amended, stands part of the bill. All those in favor say aye. All those against say no. Honorable members, the ayes have it. Clause 22, as variously amended, stands part of the bill. Yes.
Mr. Speaker, sorry to take you back one step. Just indulge me. Mr. Speaker, on the sources of funding, I wanted to just do something quickly, if you would.
Is it on 22?
No, Mr. Speaker, I'm saying that I'm taking you back. The funding, Mr.
Leader,
Speaker,
we know something. We know something. Let's note it down. When you finish, we can.
Mr. Speaker, we can look at this. Something minor. It's something minor. It's not anything.
Leader, let's do it this way.
Second, okay,
you can have second consideration.
Mr. Speaker,
so that we look at all these things.
The leader of the House doesn't appear difficult this afternoon. So it doesn't appear difficult. Once he says that second consideration, we can look at it. It's okay. The records have heard him. Hansard has heard him. That second consideration, we look at it. It's okay.
Very well. Chairman, clause 23.
Requirement to obtain accreditation.
Chairman, is there any proposed amendment?
Mr. Speaker, there is. Mr. Speaker, amendment proposed. Clause 1, line 1. Delete. A person in charge of a law degree program of a university, and insert a university that runs Bachelor of Laws degree program. Mr. Speaker, the new rendition will be A university that runs a Bachelor of Laws degree program shall not offer or provide law practice training unless the university has obtained accreditation from the council. I so move, Mr. Speaker.
Honourable members, a proposed amendment from the chairman. I then put the question. All those so, honourable members, all those in favour of the proposed amendment to clause 23 say aye. All those against say no. Honourable members, the ayes have it. Clause 23, subclause 2, amendment is hereby adopted. Chairman, clause 23, same 23. Is there any further?
This amendment was in respect of 23.1, but
yes,
you inadvertently mentioned 23.2. So it should be 23.1. We will now go to 23.
Well,
yeah.
Honourable members, I take the question again. The proposed amendment to clause 23.1, all those in favour say aye. All those against say no. Honourable members, the ayes have it. Clause.
Yeah, Mr. Speaker, that is issue of provisional accreditation license, correct? Because you keep changing.
No.
What's
that? Is requirement to obtain accreditation.
So that has become the 22. Okay.
The question, the motion is adopted.
Yes.
And clause 23.1 is hereby adopted. Yes, Chairman.
Speaker, we'll continue with the second proposed amendment in the clause. Subclause 2, line 1, delete person and insert university that. In line 2, delete 10 and insert 50. And in line 3, delete 20 and insert 100. The Speaker, the new rendition will be a university that contravenes subsection 1, commits an offense and is liable on summary conviction to a fine of not less than 50,000 penalty units and not more than 100,000 penalty units. I so move, Mr. Speaker.
Thank you very much. Honourable members, the proposed amendment to clause 2 by the chairman. The question is, all those in favour of the proposed amendment say aye. All those against say no. Honourable members, the ayes have it. The proposed amendment is carried.
Mr. Speaker, don't you think that this 10 years is too harsh? No, Mr. Speaker, let's. You see, the country is, Mr. Speaker, the country is moving towards a new sentencing regime, a non-custodial sentencing regime. Okay? And we have enactment on that. Why would we now legislate and be looking at a very long period of prison sentence? I don't think there's a proper alignment here. Yeah, no, but or no, you fine or.
Honourable members, clause 23 as variously amended. All those in favour say aye. All those against say no. Honourable members, the ayes have it. Clause 23 as variously amended stands part of the bill. Clause 24. Chairman, any proposed amendment?
Accreditation.
Chairman, any proposed amendment?
Speaker, proposed amendments. application for accreditation. The Speaker, subclause 1, line 1, delete a person in charge of a law degree program of a university and insert a university that runs a law program. The Speaker, the new rendition will be a university that runs a Bachelor of Laws degree program that seeks accreditation for the university to offer or provide law practice training shall submit an application in the prescribed form to the council. Two, an application under subsection 1 shall be accompanied with A, information on the administrative structure of the university, and B, 2, the curriculum and teaching technology, methodology of the university, B, evidence of compliance with the standards set by the council, and C, the prescribed fee. Mr. Speaker, I so move.
Thank you very much. Honorable members, the chairman has moved the proposed amendment. And the question is, all those in favor of the proposed amendment say aye. All those against say no. Honorable members, the ayes have it. The proposed amendment is carried. Now, cross 24.
25.
I put cross, yes, as it was amended. All those in favor say aye. All those against say no. Honorable members, clause 24 as variously amended is carried as you all say aye. So clause 25.
And then you can see that the last
Chairman.
No, there is another clause.
and my name has been.
So clause 25. Table. Honorable member, please, can you put off your microphone? Yes. Clause 25, table.
Consideration of application.
Yes, Chairman.
Speaker, there's no proposed amendment, subclause 4, delete.
We've missed one. There is a major. We have revised 24.
Mr. Speaker, we just want to confer on 24 and 25.
That is here.
We are on 25. Yes, consideration of application. Yes, Chairman. Or should we hold on with 25?
Mr. Speaker, I'm not a procedural expert, but I want to raise this for us to bring clarity to it. So, Speaker, we have the original paper that was laid, and as a result of winnowing, we have a new document with new clauses. Yes. Mr. Speaker, is it the case that the new document has been laid, or we are moving on the presumption that the one that was laid, which has received various amendments so substantial as a result of winnowing, will continue on that part? Mr. Speaker, I have a difficulty, because to the extent that the amendments are not minor, what we are dealing with completely changes what was earlier laid. We may have to be careful. It may not be too difficult to relay. A procedural misstep can cause us as a house, Mr. Speaker. So, Chair, you know you are dealing with a completely new document from what we are doing now. But you've had a substantial amendment. Yes, that's what I'm saying. That so you recall that honorable chair of winnowing, honorable chair of winnowing. Well, he's in charge of winnowing. Yeah, but when the whip is arrogating powers. Okay, very well. So, very well, Mr. Speaker. My simple issue is that this document we are dealing with now is a completely new document. If we want to use it as a guide, let's say so. Because, Mr. Speaker, in the past, where at winnowing, we have done substantial work leading to a new thinking. The old paper had been withdrawn, and we've allowed a new one to be used.
Honorable Chief Whip, you resume.
You see, so Mr. Speaker, he is my junior in this chamber, and Mr. Speaker, we are talking about this chamber. Yeah, but we are talking about this chamber, House of Parliament. Mr. Speaker, I don't want the majority leader to rub it in that he is also a senior to me, so I will not pursue this matter. But, Mr. Speaker, my colleague, the firm must allow. We have precedents. This House, we work with precedents. We work with our own conventions and practices. This law, this bill, at winnowing, has seen massive changes, and you concede to that. There's a whole confusion. And Mr. Speaker, I am of the view, and I respectfully submit, firmly and in all humility, that it will be better for us to withdraw the old paper and relay and proceed.
Minority
Honorable Leader.
Speaker, first of all, it is procedural impropriety for us to go consider a bill, bring a report with amendments, and say that we are going to relay afresh. That is not what Parliament, that is not what we do. The intent of this House is that when a mandate is given to a committee to consider an instrument or a bill, you ought to bring a report. A report was brought with some amendments, and in the wisdom of the House and the Speaker, winnowing committee ought to go and do winnowing, as the term suggests. And it was exactly what we did. And in doing the winnowing, We need to advertise what we are seeking to win and leave the chaff, take the chaff away and leave the grain. That is why in advertising what we are taking away, we have advertised what we are deleting and leaving the grains.
Thank you, leader.
The minority leader hasn't been here for some time, for about 2 to 3 weeks. He hasn't been here.
It still doesn't matter.
Let's move on. He's dealing with a bill that...
Let's move on. So, clause 25. Any proposed amendment?
Yes, Lord Speaker, we are deleting, Speaker 22, we are deleting subclause 4. And so we have subclause 1 to 3. I so move, Mr. Speaker.
Honourable members, the proposed amendment is to delete clause 4 so that you deal with clause 1 up to 3. All those in favor of the proposed amendment say aye. All those against say no. Honourable members, the ayes have it. The proposed amendment is carried. Yes, Honourable member for Asante Achin Central.
Mr. Speaker, thank you. Mr. Speaker, I'm saying this and I'm saying it the last time. Mr. Speaker, on the point that was just raised by the minority leader, at least when they were talking about seniority, I am senior to them, whether in the house or at the bar. Mr. Speaker, what I have said earlier is that there is a bill that has been laid in this house. And Mr. Speaker, they are trying to confuse the chairman and Mr. Speaker. The fact is that if you look at Order 68, the issues that have been trashed out, we may not consider them. That is the purpose of winnowing. But so far as we are concerned, it is the bill that has been laid in this house that we must deal with, not the new guide, which should be a guide. We should not make reference to this incorporated document. The chairman can at best move his amendment in accordance with the bill that is laid in this house, and then can refer us to the incorporated act as incorporated like this. But to say, and the Speaker to accept that the incorporated one is what we are dealing with, Mr. Speaker, I beg to differ. I think we are wrong. We are wrong. So without pushing the argument that we don't have to withdraw or relay, I plead with the chairman to go by the bill that is laid in this house, and then he can make reference for us to understand it the easy way and flow along. Then you can point to the incorporated one as the new rendition would be as referred to at this clause, and then you quote it, and then we go. Otherwise, because in this chamber we have done a whirl, it had gone to court, and people have challenged it, and they said that we never debated it, let alone debating a different document. Thank you.
Thank you very much. Yes, leader.
Mr. Speaker, we have 3 documents before us. 3, not 2. We have the Legal Education Reform Bill. That's the original bill that came before us. We have Legal Education Bill. And then we have the order paper. Those are 3 documents. What the chairman does is to rise up anytime that we are at an item on the order paper. That's what I've observed. So the understanding is that when the chairman rises, he moves the amendment as captured in the order paper. Okay? When he moves the amendment as captured in the order paper, instead of going back to the original to try and insert in the original how the rendition should sound like now. We asked him to go and incorporate the amendments. And it is the incorporated document that is the third document. Okay? So he moves the amendment as captured in the order paper. If you have the original, fine, you can take your original. You can try to insert it yourself and see how the new rendition is. But to make it easy, the chairman gets up and then he now reads the new rendition for ease of understanding. You get it? So that is what is happening. So that it is making it easy for us. But imagine if let's say that, and that's why we printed the incorporated document and shared to everybody who is interested in participating to make it easy. So that when you now want to even make a further amendment, it is easier for you because you have the new rendition which captures the intended amendments of the chairman. It makes it easy for you who has a further amendment. And that is why a lot of your colleagues are able to make further amendments. Otherwise, it would have been very, very cumbersome. Now, you talk about withdrawing and relaying. Mr. Speaker, before he traveled, he organized a big conference, a press conference in this country. A very big press conference. And said that this government has been passing bills under certificate of agency. We've been abusing that. And that we've been abusing the certificate of agency. It is to respond to him that we took a decision that we will not withdraw a bill and relay. Because when we withdraw and relay, then we'll take it through certificate of agency because, I mean, the work has been done. So, under this arrangement, one, we allow the young ones, the new members, to sit and observe. It's a bit laborious, but in the process they are learning. And I can see a lot of the backbenchers have picked up the skills quickly, and they are participating, effectively. And we encourage that. So the culture of withdrawing bills when they go to committees, and then, coming to relay a withdrawn bill, and then we rush through the bill without going through the details, it doesn't help for training the younger members of the House. So, Mr. Speaker, let's just continue along those lines. Our target has been to do 20 clauses a day. And if we all just bear with the chairman and assist, we can finish the 20 clauses and then we can adjourn.
Thank you very much. Honourable members, we've already effected clause 25 amendment. So,
Mr. Speaker, if you pay due regard to clause 25, yes, the new one, the clause 25(2). Mr. Speaker, dealing with consideration of application, we realize that in 25(1), there's a provision, quote, the council shall, on receipt of an application for accreditation, constitute a committee to conduct evaluation of the university that seeks to offer or provide law practice training. Then 2, the committee constituted under subsection 1 shall, then its responsibility is outlined. But Mr. Speaker, we don't have to legislate in absurdity. We don't have to legislate without providing clarity. This committee that we refer to be constituted, how would it be composed? I think as legislators, we should define and give a complete breakdown of how this committee will be composed and constituted. Mr. Speaker, in view of that, I would want to move that we insert
a new subclause 1A, 1B. We have a subclause 1B that would state that the committee constituted under subclause 1 shall consist of A, a chairperson, B, no less than 6 other members appointed by the council, and membership shall include at least 1 representative of the judiciary, 1 representative of the Ghana Bar Association, though now they are now introducing some other thing. Ghana Bar Association, you are a member of the bar. 1 person in the academia in legal education of no less than the rank of senior lecturer, 1 representative of the Ghana Tertiary Education Commission, and 1 person with expertise in quality assurance in higher education. Mr. Speaker, I am of the view that considering the work that has to be done in this whole legislation, this is such an important committee because it is the committee that would consider application for consideration. And that composition of that committee would be at the heart of the work of this institution to be created. So, Mr. Speaker, without more, I would want to rely on the proposed composition and want to invite members to make their own input. If there is none, then we would keep it as it is. But Mr. Speaker, there's an obvious opposition that will come because somebody has managed to get a certain law, something. I don't even know. But as far as I know, we have Ghana Bar Association. You know, as far as I know, Ghana Bar Association.
Yes, let me listen to the Attorney General.
Thank you, Right Honorable Speaker. Right Honorable Speaker, if you look at the tenor of the provision in question, this is a committee of the council. It's a committee of the council. It's like saying that you set up the board of a state agency, and then the committees of the agency, you name them ahead. You name the membership ahead. I think these are ad hoc committees that are formed for specific, for a specific duty. So I do not think that it is proper to name the membership of the committee, that is, to constitute the committee, for the council. We should leave that to the council itself, from time to time to set up that committee for the purpose of carrying out the duty of accreditation.
Mr. Speaker, I do not think that, and with greatest deference to my respected senior and professor, Mr. Speaker, I do not think that it will be proper to make this an ad hoc committee. Let's legislate on it. Let's bring clarity because, Mr. Speaker, in establishing this legal entity, their main work, with all the things we're saying, they are there to give accreditation. That is all that we say. To give accreditation to various universities, of course, but you deal with the fundamentals first. You can't place something or nothing, it will fall. So if you are able to get the right thing, infrastructure right, you are able to now rely on same to maintain standards. Mr. Speaker, it is not the right way to proceed if we say there should be an ad hoc committee of council. The committee to do the whole work of considering application must be clearly defined in the enactment. It's not one of those ad hoc committees that must be set up at the pleasure of council. No. They are there to do a fundamental work, accreditation, consideration of applications.
So, Mr. Speaker, if an important committee like this, you don't have legislate on who and who should be on it, someone with quality assurance expertise in higher education, Mr. Speaker, a representative in the academia in the area of legal education, a representative from Ghana Tertiary Education Commission, a representative from the judiciary.
So are you proposing them?
Yeah, Mr. Speaker, yes, I've outlined them. It's in the other paper addendum. My proposed amendment is advertised.
So proposed amendment. Honourable members, in order that we move faster, he's proposing an additional sub-clause. So I'll ask him to put come out with the rendition again. You put the question there.
Yes, it's there. It's there. Yes.
Okay. So, leader, let me hear you. So, if I need to put the question, you put the question and you move.
Yeah, Mr. Speaker, I think that what he has said is a very sound issue. But it is important to understand the new structure. What you are talking about is now the function of the council. That is the function of the council. So if you go to clause 4, you will see that the council as constituted reflects these interest groups that you are proposing to make up the committee. You see, so you will see that the governing council has one retired justice of the Supreme Court or a person who qualifies to be appointed as a justice of the Supreme Court, 3 representatives of the judiciary, one of whom is from a lower bench nominated by the Chief Justice, 1 representative of the Attorney General and Minister of Justice, 3 representatives of the bar, 1 representative of the ministry responsible for education, then the Tertiary Education Commission, and 3 persons who teach law in accredited universities nominated by the Conference of Law Deans. This council is responsible for the licensing job. So they will form the committee. The committee will obviously be drawn out of these same people. And so it will be creating another institution
within the council.
Within the council, if you now go and say that there must be a committee made up of all that, because, listen, yes.
Yeah, we learn from each other. Mr. Speaker, that clarity being provided, I think then that to make it simpler, that the committee be drawn from membership of the council. No, wait. It doesn't, no, what is there doesn't say so. Mr. Speaker, with respect,